Hello and welcome to this presentation on state laws governing Missouri jails and jail staff. There are many different state statutes, local court rules, and Missouri Supreme Court rules that directly or indirectly affect jail staff as well as jail operations. This lesson covers the most common statutes staff are likely to be affected by. Keep in mind that these are only a few statutes that govern Missouri jails, and you should educate yourself on all Missouri statutes on this topic. You can do this by going to www.revisor.mo.gov. Before we begin the lesson, I want to take the opportunity to explain the scope, terminal learning objective, and the enabling learning objectives for this training. Upon completion of this lesson, the participant will be able to identify the most common state statutes, local court rules, and Missouri Supreme Court rules affecting jail operations. Upon completion of this presentation, the participant will be able to 1. Identify when sheriffs are required to be jailers. 2. Identify the requirements and exceptions for jails to receive prisoners. 3. Identify the circumstances and requirements when juveniles are held in jail. 4. Identify a jailer's responsibility relating to seeking medical attention for an inmate. 5. Identify how inmates of different sex must be housed. 6. Identify what computer checks must be done before an inmate is released. 7. Identify the length of time a person may be held without charges being filed, a warrant issued. The first statute we will discuss is sheriffs to be jailers, except as otherwise provided in this section, and sections 221.400 to 221. 420. The sheriff of each county in this state shall have the custody, rule, keeping, and charge of the jail within his county, and of all the prisoners in such jail, and may appoint a jailer under him, for whose conduct he shall be responsible. In any first-class county without a charter form of government which contains all or part of a city with a population of at least 300,000 inhabitants, the sheriff and the county commission, by mutual agreement, may have the control of the county jail transferred to the county commission. The next statute is the coroner to be jailer 221.030. The sheriff may be imprisoned in the jail of his own county, and for the time that he shall be confined, the coroner shall have the custody, rule, keeping, and charge of the said jail, and shall, by himself and his sureties, be answerable for the faithful discharge of his duties in that office. Let's talk about Statute 221.040. Sheriff and jailers to receive prisoners. 1. It shall be the duty of the sheriff and jailer to receive, from constables and other officers, all persons who shall be apprehended by such constable or other officers for offenses against this state, or who shall be committed to such jail by any competent authority, and if any sheriff or jailer shall refuse to receive any such person or persons, he or she shall be adjudged guilty of a misdemeanor, and on conviction shall be fined in the discretion of the court. 2. The sheriff and jailer shall not be required to receive or detain a prisoner in custody under subsection 1 of this section until the arresting constable or other officer has had the prisoner examined by a physician or competent medical personnel if the prisoner appears to be unconscious, suffering from a serious illness, suffering from a serious injury, or seriously impaired by alcohol, a controlled substance as defined in section 195. 17. A drug other than a controlled substance, or a combination of alcohol, a controlled substance, or drugs. 3. The cost of the examination and resulting treatment under subsection 2 of this section is the financial responsibility of the prisoner receiving the examination or treatment. A few things to consider when interpreting. Many refer to this as the fit for confinement statute. Although that may have been the intent of the legislators when the language passed, one should proceed with caution when interpreting it that way. Without going into great detail on how statutes are constructed, reviewed, and how the courts interpret intent of legislation, here are a few points of concern. The plain language of the statute requires only that a prisoner under certain circumstances be examined by a physician or competent medical personnel prior to jail staff being required to accept them into the jail. The law does not define examined as used in the context of its use. However, it does reference the cost of the examination. Looking to the common ordinary meaning, we find that medical examination means the preliminary assessment of a person by an authorized health worker or by a person under the direct supervision of the competent authority, to determine the person's health status. Once the prisoner has been examined, seen, so to speak, the law may not provide the authority for a facility/jailer to turn the prisoner away because the type of documentation the facility has determined by policy that it needs has not been provided. An additional point of consideration is that the law does not define competent medical personnel as used in the context of examined by a physician or competent medical personnel, 46 CFR 4003-6, qualified medical personnel. The term qualified medical personnel means a physician, physician's assistant, nurse, emergency medical technician, or other person authorized under state or federal law or regulation to collect blood and urine specimens. Qualified medical personnel, or QMP, means an individual other than a licensed physician who is designated as qualified to administer one or more types of medical screening examinations and/or complete and sign a transfer certification in consultation with the physician. Note: agencies that require the prisoner be seen only by a doctor or physician should proceed with caution and check with legal counsel on such a policy. Statute 221.044, person under 18 not to be confined in adult jails. No person under the age of 18 years, except those transferred to the Court of General Jurisdiction under the provisions of Section 211-71, shall be detained in a jail or other adult detention facility as that term is defined in Section 211. 151. A traffic court judge may request the juvenile court to order the commitment of a person under the age of 18 to a juvenile detention facility. RSMO 201.072 certification as an adult placement in jails. A juvenile under 18 years of age who has been certified to stand trial as an adult shall remain housed in a juvenile facility unless a judge orders the juvenile to be transferred to and housed in an adult jail. In the event the court finds that it is in the best interest of justice to require the certified juvenile to be held in an adult jail, the court shall hold a hearing once every 30 days, 30, to determine whether the placement of the certified juvenile in an adult jail is still in the best interests of justice. See note below. A certified juvenile cannot be held in an adult jail for more than 180 days unless the court finds, for good cause, that an extension is necessary or the juvenile, through counsel, waives the 180-day maximum period. If no extension is granted under this subsection, the certified juvenile shall be transferred from the adult jail to a secure juvenile detention facility. All pretrial certified juveniles under 18 years of age who are held in adult jails pursuant to the best interest of justice exception shall continue to be subject to the protections of the PREA and shall be physically separated from adult inmates. Upon attaining 18 years of age or upon conviction on the adult charges, the juvenile shall be transferred from juvenile detention to the appropriate adult facility. Any responsibility for transportation of and contracted service for the certified juvenile who remains in a secure juvenile detention facility shall be handled in the same manner as in all other adult criminal cases where the defendant is in custody. Note: it is unknown who is responsible for tracking whether a hearing is held every 30 days to see if the juvenile should remain in jail. It is also unclear what should happen with the juvenile if the hearings are not held. Statute 221.050. Separation of prisoners. Persons confined in jails shall be separated and confined according to sex. Persons confined under civil process or for civil causes shall be kept separate from criminals. Nothing in this section shall be construed to prohibit the housing of persons on probation or parole with offenders or persons being held on criminal charges. Statute 221.060. Prisoners to have certain privileges. Every sheriff and jailer and other person or persons whatsoever to whose custody or keeping any person or persons shall be committed by virtue of any writ or process, or for any criminal offense, except on conviction for felony, shall make and post reasonable rules for the operation of the jail, and shall permit any such person committed to his care to obtain and use food and bedding at such person's expense within those rules as may be convenient and necessary for the proper operation of the jail or confinement facility. RSMO 600, 048. Right to counsel. Notice posted. Where contents. It shall be the duty of every person in charge of a jail, police station, constable's or sheriff's office, or detention facility provided by any county to post in a conspicuous place a notice stating in effect: 1. That every person held in custody under a charge or suspicion of a crime is entitled to have a lawyer. That if any such person is held in custody in connection with any of the cases or proceedings set out in Section 600, 42, and wants a lawyer to represent him or her, and is unable, without substantial financial hardship to self or his or her dependents, to obtain a lawyer, the state will provide a lawyer to represent him or her upon request. And 3, that if the state provides such a lawyer, the client may be liable to the state for the cost of the services and expenses of the lawyer who handles the case if he or she is or will be able to pay all or any part of such costs. The notice shall also contain a listing of the cases and proceedings for which defender services are available under Section 600, 042, and the telephone number of a person or answering service to call to request that a person designated by the state public defender system visit and interview him or her, and provide further information. RSMO 600.048 3 must make room to meet with attorneys. It shall be the duty of every person in charge of a jail, police station, constable's or sheriff's office, or detention facility to make a room or place available therein where any person held in custody under a charge or suspicion of a crime will be able to talk privately with his or her lawyer, lawyer's representative, or any authorized person responding to a request for an interview concerning his or her right to counsel. RSMO 221.65 Feminine Hygiene Products, available at no cost. 1. As used in this section, the following terms mean 1. Appropriate quantity, an amount of feminine hygiene products per day capable of satisfying the individual need of the offender if used for the feminine hygiene products' intended purpose. 2. Feminine hygiene products, tampons, and sanitary napkins. 2. Every sheriff and jailer who holds a person in custody pursuant to a writ or process or for a criminal offense shall ensure that an appropriate quantity of feminine hygiene products are available at no cost to female persons while in custody. The sheriff or jailer shall ensure that the feminine hygiene products conform with applicable industry standards. 3. The General Assembly shall appropriate funds to assist sheriffs and jailers in satisfying the requirements of this section. RSMO 221.1 1 Delivery or concealment of prohibited items. 1. A person commits the offense of possession of unlawful items in a prison or jail, if such person knowingly delivers. Attempts to deliver, possesses, deposits, or conceals in or about the premises of any correctional center, as the term correctional center is defined under Section 217.010, or any city, county, or private jail. 1. Any controlled substance as that term is defined by law, except upon the written or electronic prescription of a licensed physician, dentist, or veterinarian. 2. Any other alkaloid of any kind or any intoxicating liquor, as the term intoxicating liquor is defined in Section 311. 020. 3. Any article or item of personal property which a prisoner is prohibited by law, by rule made pursuant to Section 221.060, or by regulation of the Department of Corrections from receiving or possessing except as herein provided. 4. Any gun, knife, weapon, or other article or item of personal property that may be used in such manner as to endanger the safety or security of the institution, or as to endanger the life or limb of any prisoner or employee thereof. 2. The violation of subdivision 1 of subsection 1 of this section shall be a Class D felony. The violation of subdivision 2 of this section shall be a Class E felony. The violation of subdivision 3 of this section shall be a Class A misdemeanor. And the violation of subdivision 4 of this section shall be a Class B felony. 3. The chief operating officer of a county or city jail or other correctional facility, or the administrator of a private jail, may deny visitation privileges to or refer to the county prosecuting attorney for prosecution any person who knowingly delivers, attempts to deliver, possesses, deposits, or conceals in or about the premises of such jail or facility any personal item which is prohibited by rule or regulation of such jail or facility. Such rules or regulations including a list of personal items allowed in the jail or facility, shall be prominently posted for viewing both inside and outside such jail or facility in an area accessible to any visitor and shall be made available to any person requesting such rule or regulation. Violation of this subsection shall be an infraction if not covered by other statutes. 221.70 Prisoners liable for cost of imprisonment. Certification of outstanding debt. 1. Every person who shall be committed to the common jail within any county in this state by lawful authority, for any offense or misdemeanor, upon a plea of guilty or a finding of guilt for such offense, shall bear the expense of carrying him or her to said jail, and also his or her support while in jail, before he or she shall be discharged. And the property of such person shall be subjected to the payment of such expenses, and shall be bound therefore from the time of his commitment, and may be levied on and sold from time to time, under the order of the court having criminal jurisdiction in the county, to satisfy such expenses. 2. If a person has not paid all money owed to the county jail upon release from custody, and has failed to enter into or honor an agreement with the sheriff to make payments toward such debt according to a repayment plan, the sheriff may certify the amount of the outstanding debt to the clerk of the court in which the case was determined. The circuit clerk shall report to the office of State Courts Administrator the debtor's full name, date of birth and address, and the amount the debtor owes to the county jail. If the person subsequently satisfies the debt to the county jail, or begins making regular payments in accordance with an agreement entered into with the sheriff shall notify the circuit clerk, who then shall notify the State Courts Administrator that the person shall no longer be considered delinquent. RSMO 221-120 Medicine and Medical Attention for Prisoners. If any prisoner confined in the county jail is sick and in the judgment of the jailer requires the attention of a physician, dental care, or medicine, the jailer shall procure the necessary medicine, dental care, or medical attention necessary or proper to maintain the health of the prisoner. The costs of such medicine, dental care, or medical attention shall be paid by the prisoner through any health insurance policy as defined in subsection 3 of this section, from which the prisoner is eligible to receive benefits. If the prisoner is not eligible for such health insurance benefits, then the prisoner shall be liable for the payment of such medical attention, dental care, or medicine, and the assets of such prisoner may be subject to levy and execution under court order to satisfy such expenses in accordance with the provisions of Section 221.070 and any other applicable law. The County Commission of the county may at times authorize payment of certain medical costs that the County Commission determines to be necessary and reasonable. As used in this section, the term medical costs includes the actual costs of medicine, dental care, or other medical attention and necessary costs associated with such medical care such as transportation, guards, and inpatient care. The County Commission may, in their discretion, employ a physician by the year to attend such prisoners and make such reasonable charge for his service and medicine, when required, to be taxed and collected as provided by law. Note, you cannot let an inmate go without needed medication. RSMO 221.353 Damage to jail property. 1. A person commits the offense of damage to jail property if such person knowingly damages any city, county, or private jail building or other jail property. 2. A person commits the crime of damage to jail property if such person knowingly starts a fire in any city, county, or private jail building or other jail property. 3. Damage to jail property is a Class E felony. RSMO 221.503 Mules. Notification of escape of dangerous felon. 1. As soon as reasonably possible, but in no case more than 5 hours after a person who has been convicted of murder in the first degree or a dangerous felony as defined in Section 556. 061 or who is being held on suspicion of having committed murder in the first degree or a dangerous felony as defined in Section 556. 061 has escaped from a municipal detention facility, county jail, regional jail, or private jail, the chief law enforcement official responsible for such jail or detention facility, or the chief administrator in the case of a private jail, shall cause notification of the escape to be made to the Missouri Uniform Law Enforcement System, MULES. 2. The notification required by this section may include the name of the escaped individual, any facts relevant to identifying the escaped individual, including but not limited to a physical description, a photograph or video of such individual, a description of any mode of transportation such individual is believed to be using, and a description of any person believed to be assisting such person in the escape, if any. The notification shall also include the crimes for which the person was incarcerated in the jail or detention facility and contact information for the jail or detention facility, which can be used by any person to report any information concerning the whereabouts of the escaped person. RSMO 221-510, pending outstanding warrants in MULES and NCIC. 1. Every chief law enforcement official, sheriff, jailer, administrator of a private jail, Department of Corrections official, and regional jail district official shall conduct an inquiry of pending outstanding warrants for misdemeanors and felonies through the Missouri Uniform Law Enforcement System, MULES, and the National Crime Information Center, NCIC system on all prisoners about to be released, whether convicted of a crime or being held on suspicion of charges. 2. No prisoner, whether convicted of a crime or being held on suspicion of any charge, shall be released or transferred from a correctional facility or jail to any other facility prior to having a local, state, or federal warrant check conducted by a law enforcement official, sheriff, authorized member of a correctional facility or jail, or administrator of a private jail. 3. If any prisoner warrant check indicates outstanding charges or outstanding warrants from another jurisdiction, it shall be the duty of the official conducting the warrant check to inform the agency that issued the warrant that the correctional facility or jail has such prisoner in custody. That prisoner shall not be released except to the custody of the jurisdictional authority that had issued the warrant, unless the warrant has been satisfied or dismissed, or unless the warrant issuing agency has notified the correctional facility or jail holding the prisoner that the agency does not wish the prisoner to be transferred or the warrant to be pursued. 4. If any person has actual knowledge that a violation of this section is occurring or has occurred, such person may report the information to the Attorney General of the State of Missouri, who may appoint a sheriff of another county to investigate the report. 5. If a law enforcement official, sheriff, authorized member of the correctional facility or jail, or administrator of a private jail purposely fails to perform a warrant check with the intent to release a prisoner with outstanding warrants, and which results in the release of a prisoner with outstanding warrants, that individual shall be guilty of a Class A misdemeanor. 6. A law enforcement official, sheriff, authorized member of the correctional facility or jail, or administrator of a private jail shall not be deemed to have purposely failed to perform a warrant check with the intent to release a prisoner in violation of this section, if he or she is unable to complete the warrant check because the MULES or NCIC computer systems were not accessible. RSMO 5460 24 hours detention on arrest without warrant. 1. All persons arrested and confined in any jail or other place of confinement by any peace officer without warrant or other process for any alleged breach of the peace or other criminal offense or on suspicion thereof, shall be discharged from said custody within 24 hours from the time of such arrest, unless they shall be charged with a criminal offense by the oath of some credible person and be held by warrant to answer to such offense. 2. In any confinement to which the provisions of this section apply, the confinee shall be permitted at any reasonable time to consult with counsel or other persons acting on the confinee's behalf. 3. Any person who violates the provisions of this section by refusing to release any person who is entitled to release pursuant to this section, or by refusing to permit a confinee to consult with counsel or other persons, or who transfers any such confinees to the custody or control of another, or to another place, or who falsely charges such person with intent to avoid the provisions of this section, is guilty of a Class A misdemeanor. Note: this statute is not intended to be an investigative tool for police, but sets a limit on the time a suspect may be detained, whose arrest was otherwise lawful, while determining whether there is sufficient evidence of a crime to take to a judge or prosecutor. Therefore, any interpretation of Section 54404-70, which includes authority for making investigative arrests, would clearly be unconstitutional. US v. Roberts, 928 F. Suppi 910, WD Mo. In closing, we want to thank you for attending this class, and we hope you enjoyed it and learned something new. As already stated, there are many different state statutes, local court rules, and Missouri Supreme Court rules that directly or indirectly affect jail staff as well as jail operations. Keep in mind that these are only a few statutes that govern Missouri jails, and you should educate yourself on all Missouri statutes, court rules, and court decisions on this topic. Becoming knowledgeable of these governing principles will make better equipped to perform your duties.